Let's go over why the new regulation for digital accessibility under Title II of the Americans with Disabilities Act is so important. Starting with the first reason on the whiteboard, we finally have a formal legal precedent set out by the Department of Justice. The DOJ is the regulatory and enforcement agency behind Title II and Title III of the ADA. Their longstanding position has been that the ADA does apply to websites and mobile apps, but until now, we haven't known exactly what is necessary to make these different digital assets accessible. And now we do, albeit it's only for Title II. So this only applies to state and local governments. But what's especially nice about this regulation coming first is now we have a preview for Title III regulation. And the DOJ also has time to gather information and really learn from the Title II regulation and apply what they learned to Title III. We'll get to that in a moment. In Title II, we saw a very nice consideration for the size of the entity. So the DOJ made the distinction: if you're a smaller government, we're going to give you longer for compliance. And if you're a larger entity, if you're a larger government, then you're going to have 2 years for compliance. So that was very helpful. We also saw WCAG 2.1 AA incorporated. WCAG 2.1 AA has been a best practice for accessibility and preventing lawsuits that I've talked about for years, but now we see WCAG 2.1 AA formally incorporated. And what's nice is the DOJ set out a provision for minor issues. So if you are close to conformance, but you have a minor issue, it doesn't necessarily mean that you're in violation of the ADA. I think with Title III regulation, we'll see more details for this. But it was good that the DOJ took into account that you may have a minor accessibility issue that doesn't constitute a barrier to access or a significant detriment in accessibility. And we also saw the DOJ take into account like more web content, social media, and documents. So PDFs, spreadsheets, PowerPoints, and Word documents. All of these different types of documents were taken into account, and they fall under web content. So not only documents but social media were contemplated, and they are in Title II regulation. We also saw the DOJ make a very pragmatic and necessary consideration in that there are multiple exceptions for pre-existing content. So if there are age documents, if there are documents that are rarely accessed, then those will not need to be made accessible because the DOJ recognizes the reality that some entities have literally tens, if not hundreds or thousands of documents where it would be cost prohibitive to make them all accessible. So the DOJ really did website owners a favor with pre-existing content exceptions. Now, a few other points I have on the whiteboard. How does this matter in today's current legal landscape? Well, Title II regulation could help plaintiffs' lawyers because now they can point to Title II and state, okay, the DOJ itself set out WCAG 2.1 AA as a best practice. So this is what is required for private entities. Even though there isn't regulation, we have seen lawsuits going forward, and the DOJ has stated that private entities need to make their websites accessible. But now we see that they have set out WCAG 2.1 AA as a best practice. So technical nonconformance with these standards means that there is noncompliance. Title II could also help the defense because the defense can say, well, the DOJ set out that the large governments have 2 years for compliance, and that the smaller public governments, these small public entities, have 3 years for compliance. So we should have the same amount of time for compliance. Regulation still hasn't been issued, so the defense could make arguments towards that end. Also, as I mentioned previously, the DOJ is going to benefit from having this Title II regulation out there while it works on Title III. And I expect Title III to come shortly. So expect about 2 or 3 years away is a good estimate. It may be slightly longer, but hopefully it's sooner. I have to think that the DOJ was thinking about Title III regulation the whole time it was working on Title II regulation. So I think there will be a lot of the constructs and the framework already in place. But I think we will see more details, and the DOJ is going to watch and see what the effects of Title II regulation are, and then from what it learns, it's going to incorporate some of those learnings into this new Title III regulation. But when Title III regulation is issued, there is the potential for lawsuits to come to a stop, or at least slow down. Because if you think about it, if Title III regulation includes different deadlines, then those deadlines in effect mean that private entities or places of public accommodation, they have that time necessary to come into compliance. So that would be an extremely helpful defense if you were to defend against one of these cases. So there is a lot there's uncertainty here. We're not exactly sure how this is going to play out in the court system. Given that we've had private litigation for years. The DOJ stance is that the ADA does apply to websites and mobile apps. We just don't have formal regulation on the Title III side yet. So there is uncertainty going forward. But the Title II regulation does help. Of course, this is going to ensure access to all types of public entities, but it's also, I think, going to accelerate private entities in how they react, especially given that there's already an ultra litigious environment. So the Title II regulation, I think, is already helpful. I think the sequence is especially beneficial because the DOJ can build on the Title II regulation, what it learns from the effects of the Title II regulation, the reaction, and it can further build on that to create a really robust Title III. But we do have a nice preview into, I think, some themes that will carry forward. It's not necessarily, we won't see exactly the same thing, but we will see some themes. And so one nice theme, of course, was the distinction between the entities of different sizes. I also like the provision for minor issues. We'll see what else is in Title III regulation. But this is a really, really important regulation. It is really a milestone. This is truly a milestone. So really important. If you need help with website accessibility, I offer consultation as well as accessibility services, including audits, remediation, and user testing at accessible.org. I also offer training on the Web Content Accessibility Guidelines at adacompliance.net. If you are concerned with lawsuits, I have the ADA Compliance course, which tells you the exact issues that plaintiffs' lawyers are most commonly claiming in complaints filed in court. This is going to really help in terms of making your website unattractive to plaintiffs' lawyers and really reducing your risk of litigation as you are genuinely improving the accessibility of your website. I will include links to those resources in the description below.